This slideshow is the presentation of U.S. Bankruptcy Court offer instructions for buying real estate. It is a guide meant for real estate agents and buyers of properties within the bankruptcy system. Before we begin the presentation, understand this overview is not meant to be comprehensive. It's meant to just touch on the important points that you need to understand, but not all the points. Therefore, you must read the documents that are associated with the MLS listing for a particular property to fully understand the terms and conditions of this purchase. And like all legal documents, discuss any questions you have with an attorney. Let's start the presentation. The first thing to understand is a bankruptcy sale is an open sale. That means bids can be put in up until the day that the bankruptcy judge actually signs the order approving the sale of the property. This could take between 3 and 8 weeks from the first offer submission. Also note that the trustee reserves the right to make a call for best and final offers before signing off on a final offer. And offers are also a matter of public record. That means that whatever you bid is not secret. Someone else could come along 2 days later and review your contract and make a bid for a higher price to purchase the property or offer better terms than what you have in your offer. So be aware of that whatever you put in the contract is not private. The property is an as-is sale. That means the condition it's in when you sign the contract and when it's accepted is the condition you're getting the property in. There is no recourse because you found some hidden defect after you made the purchase. You must do your own complete due diligence and decide the property is acceptable for you before you submit an offer. Financing. Financing is allowed to buy a bankruptcy property. There are some conditions. It can only be a cash or conventional financing property. You cannot use FHA, VA, USDA, or CDA financing. Those are not acceptable and your offer will be immediately rejected. The buyer is allowed to have a financing contingency and has 30 days to provide a loan commitment. However, bids without a financing contingency will be given priority. So if you have a bid for $100,000 with financing and another person has a bid for $100,000 with no financing, the other bid has a higher priority than your bid and would be the one that's accepted. Inspections. You are allowed to have an inspection contingency in your purchase contract. It can be for as long as 10 days after the seller signs the agreement. Now, equivalent offers without an inspection contingency have priority, just like with the financial contingency. If 2 offers come in at the same price and one does not require an inspection, that will be the contract that would win the property. Fees. There are fees you need to be aware of. As a buyer, you're going to pay all the fees associated with the property, and this includes the seller's closing costs. Additionally, the bankruptcy trustee court charges a sliding fee for their processing and paperwork. That fee starts at $15,000 and goes up. There is a schedule in the bankruptcy paperwork that will let you know exactly what that fee is. Fees, including the bankruptcy trustee fee and the seller's closing costs, and of course the buyer's closing costs, cannot be financed if you're purchasing the property with financing. Fees are non-negotiable. They are what they are. You cannot negotiate them. If you try, your contract will be rejected. Offer price. Before you make an offer, be sure to calculate the total cost out of your pocket to buy the property. For instance, if all you want to spend is $100,000 on the property, make sure you deduct from that $100,000 the fee, which in this case would be $15,000, plus the 1.5% seller closing cost, about $1,500. So basically, if you want to spend $100,000 on the property, your offer should be in the ballpark of $83,000, not $100,000, because the fees are tacked on above the offer price. Proof of funds. Just like any property purchase nowadays, you need to provide proof of funds when you make the offer. If you're a cash buyer, this means proof that you have the cash available to make the purchase. For a buyer who's financing, this means proof that you have the cash available for the down payment and all the fees, and a pre-qualification letter for the remainder, the part that you're financing. Minimal contingencies. You're allowed to only have 2 contingencies in a bankruptcy contract. You can have a financing contingency and you can have an inspection contingency. Both of those terms are spelled out in the paperwork. No other contingencies or contract agenda are allowed, and putting them in will cause your contract to get rejected. Read the paperwork. This is the end. Make sure that you print out and completely read the paperwork associated with the MLS listing. It is going to become a part of your offer, and the terms in the paperwork are binding, just like the terms in the contract itself are binding. So make sure you read and understand all the associated paperwork before you make an offer on this property. That covers the entire basic presentation. If you don't know how to get the paperwork, contact your realtor and your realtor will get the paperwork for you. Thanks for listening.